So Mike, the uniform law has been introduced. What are some of the aims of the legislation as it applies in Victoria and New South Wales?
Interesting question, Paul. We are now faced with a new regime in many respects. The uniform law commenced operation on the 1st of July this year, 2015, and it replaces the Legal Profession Act in both New South Wales and Victoria. And the aims of the uniform law are quite clear and broad-reaching to promote the interjurisdictional consistency between those states and any other state that might take up the law. At this stage, by way of example, the ACT is looking at introducing the uniform law themselves. Queensland, I believe, has shown some reluctance to come on board, perhaps adopting a more of a wait-and-see approach. But ultimately, the law itself is designed to promote the interjurisdictional consistency amongst states. And you need to bear in mind, of course, that between 80 and 85% of legal practitioners in Australia operate within the two states, New South Wales and Victoria. And so the uniform law itself does govern the majority, the vast majority of practitioners in our country.
And what are some of the other aims that are hope to be achieved?
Well, at this stage, it's very clear to us that the uniform law really brings across many of the aims of the Legal Profession Act and its regulations. So the maintenance and upholding of ethical and professional standards is clear amongst the aims of the uniform law. And certainly the promotion of the client's rights with respect to engaging a practitioner. But for the first time, some of the other aims that are clear amongst the uniform law are coming to the fore. And so a public interest test has been introduced in relation to not just the aims of the uniform law generally, but particularly in relation to the costs regime. And so today really what we're talking about are the costs, in particular the cost aspect of the uniform law and how the law itself impacts us as practitioners with respect to disclosure to our clients.
How would you apply a public interest test, Mike?
Well, certainly in relation to the costs aspect, that's a really interesting question. Costs would be considered more reasonable if there is an element of public interest involved. And so one might argue, for instance, perhaps costs relating to protection of consumer rights might be considered in the public interest, and therefore a higher level of costs, fees and charges may be warranted in relation to such matters. Some of the other aims, though, in the uniform law also relate to the protection of those consumer rights generally. And so for the first time we see a very interesting move amongst the requirements of a practitioner to ensure that their client is fully aware of the steps that they're taking, they're going to take in relation to litigation or other matters that their practitioners are handling for them. And so a practitioner now is required, as we'll see in some more detail later in the presentation, is required to take all reasonable steps to ensure that the client has an understanding of the steps that they're taking in a matter.
One of the tests has always been whether the work is fair and reasonable. How do you see the costs court in Victoria and the legal cost assessors in New South Wales applying that test under the new law?
Well, certainly there are some new and interesting elements that a cost assessor or the costs court must consider when considering whether or not fees and charges are fair and reasonable. And so, for instance, for the first time, the number and quantity of documents are specifically referred to within the legislation as being a factor that a cost assessor or the cost court must consider. The seniority of a practitioner who's been engaged in a matter is for the first time a consideration that must be undertaken. And certainly there are a range of different additional factors that must be considered when determining fair and reasonableness that would ordinarily be raised perhaps in a more informal setting to justify one's fees and charges. But now the Act itself codifies many of the requirements on cost assessors and the costs court when determining what is considered fair and reasonable.
I imagine many practitioners would be concerned about their costs agreements and whether they're compliant. Are they treated any differently under the uniform legislation?
Yes, indeed. In fact, under the new legislation, if a costs agreement complies with the Act and disclosure has been provided as required under the Act, the costs agreement itself is considered prima facie evidence of the fact that the costs incurred in a matter connected with that agreement are fair and reasonable. As a consequence of that, of course, it would be over to the client to establish why costs may be unfair or unreasonable. The onus shifts. And that is a fairly important step in relation to the legislation, perhaps when considering legislation that is introduced may be considered somewhere on a pendulum swinging towards the practitioner or perhaps towards the consumer. That particular provision, in my view, protects the practitioner to some extent and redresses some of the balance that has moved towards the consumer by the introduction of these new provisions.
And how have the disclosure obligations for practitioners changed under the new legislation?
Yes, it's an interesting topic, this one. Under the previous regime, if I can call it that, an estimate by way of a range of costs likely to be incurred in a matter was acceptable and quite reasonable. And so, for instance, if one was embarking on litigation, one might say to a client, ultimately, costs likely to be incurred in this matter will range between $50,000 and $80,000. That would have generally been considered a fair and reasonable disclosure. This particular provision has changed significantly. Now, under Section 174, subsection 1 of the Uniform Law, a practice is actually required to estimate the total costs involved in a matter and likely to be incurred in a matter. And so a range is actually considered potentially somewhat misleading to a client. And so it's important that practitioners move away from providing a range and now provide an estimate of the total costs. I know that this is causing quite a bit of concern amongst the legal fraternity. I've given many lectures over the last several months in relation to the changes under the Uniform Law, and this seems to be a constant concern because...
What are some of the concerns that commonly arise?
Well, ultimately, the difficulty is, of course, certainly in relation to litigation, it's very difficult to predict how much those costs are likely to be. One doesn't know, for instance, if the other side might bring a motion, potentially in relation to discovery or perhaps some other interlocutory step. And ultimately, it's very difficult to predict when that's going to happen, and so a range is a sensible approach. Now, of course, under Section 174, subsection 2, any substantial change to the costs to be incurred in a matter are also requiring disclosure to your client. And so one would expect that rather than providing a range, one would arrive at an estimate of the total costs at that snapshot in time, if you like, as to whether or not costs are likely to be incurred in a certain amount. And any change to that amount would be conveyed to the client at the time that change becomes apparent. Now, what actually forms a substantial change? I think at this stage we're going to have to adopt somewhat of a wait-and-see approach, and just to see how the courts deal with that moving forward. But certainly in the minds of a reasonable person, one might consider, for instance, a change in the total costs, perhaps an increase of more than 5% might be considered a substantial change. And certainly developments beyond, for instance, mediation. You may have estimated costs of mediation to be $50,000. mediation fails. And therefore, there is going to be a substantial change to your estimate to the point of mediation to include the hearing, because all of a sudden the hearing becomes far more likely. And one would expect costs incurred perhaps to mediation of $50,000 might be increased to, say, $120,000 if you're anticipating going to a full hearing in a matter. That would be clearly considered a substantial change. But do we expect if total costs have been estimated at $50,000 and perhaps they're going to reach $55,000, would that be considered a substantial change? Difficult to tell at this stage. However, we would always advise our practitioners that we're briefing on this to provide a fresh disclosure should the initial estimate be exceeded moving forward, to cover themselves pursuant to the legislation.
So leaving aside the changes to the fee estimates, Mike, what would you say is the other key obligation that is now imposed on practitioners?
Well, certainly there are a range of them, Paul, but one that springs to mind that is a key that really requires practitioners now to update their disclosure with respect to new engagements, bearing in mind, of course, the uniform law applies where matters involve first instructions having been received from the date of 1st of July 2015, and any matter in which your instructions have been received prior to that date, even if you've instructed counsel on client's behalf post 1 July, those matters do fall under the old regime of the Legal Profession Act. But moving forward, bearing in mind a practitioner's obligations when first instructed now fall under the uniform law, it's important that their costs agreements and their disclosure documents make it clear to their client that they have an alternative method of having their costs considered and reviewed. Clearly, the existing arrangements apply, and so your client can approach the Supreme Court and in New South Wales and the Costs Court in Victoria to seek an assessment of their costs. Now there's an additional alternative to your clients, and that is to go to the designated local regulatory authority. In New South Wales, of course, it's the Office of Legal Services Commissioner, and of course you have one in Victoria yourselves, known as the
Legal Services Commissioner.
Legal Services Commissioner.
And how would you describe the difference between that process as opposed to either an assessment of costs in New South Wales or a taxation, as we call it in Victoria?
So under the provisions relating to the authority, the designated local regulatory authority, the Commissioner, if I can call it in a sort of a generic sense, is able to consider costs applications involving costs billed of less than $100,000. In that situation, an applicant, a costs applicant being your client, can make an application to the Commissioner to have those costs assessed. If the Commissioner considers it would be best for the Costs Court or the Supreme Court to assess those costs, the Commissioner has the authority to refer the matter onto those courts. It's early days, of course. We're yet to see how a Commissioner will deal with a costs application, but one would expect matters perhaps involving simply a disclosure issue and perhaps easily resolved by the Commissioner would be more likely to be resolved in the practitioner's favour, and those perhaps more complicated might require a full assessment and potentially referral to those courts.
I notice there's a new threshold under the uniform legislation. Are you able to expand on that for us?
Well, of course you'd know that costs incurred up to $750 to date have not required disclosure. That provision is remaining in the uniform law. However, there is a new threshold, and that is the $3,000 threshold. If your costs are likely to fall under the $3,000 limit. And bearing in mind, of course, your costs include not only practitioners' fees, but also counsel fees and GST. But if they do fall under, or are likely to fall under the $3,000 threshold, you have an alternative as a practitioner to providing full disclosure, and that is simply to provide a standard form of disclosure, which is available on many websites, including Austlii, as a schedule to the Act itself. Now, you'll find that that form is a simple one to fill out, a few boxes to tick, and some details about the matter, and that will effectively absolve you from further disclosure obligations. Of course, should the thresholds change, should the matter exceed perhaps the initial threshold of $750, the new obligations arise. Again, should a matter exceed the $3,000 threshold, the new obligations arise, and of course you're obliged to provide full disclosure to your clients moving forward as required under the Act generally.
Mike, in many areas of practice, counsel or barristers are frequently engaged. Under the new law, how are the obligations of practitioners altered with respect to the engagement of counsel?
Well, here we see one of the difficulties for, in my experience, barristers. Barristers are required to provide an estimate to their instructing solicitor to enable their instructing solicitor to provide that estimate to their client. Barristers, in my experience, tend to have provided a range of fees estimated in a matter, with reason too, because ultimately it is again very difficult to know the likely costs. Let's say a hearing extends into a 5th and 6th day when perhaps an estimate was for a 4-day hearing. In that situation, common sense dictates that a range would be perhaps a more appropriate method by which to estimate one's costs. However, under the uniform law, a barrister falling under the definition of a legal practitioner that is engaged by the solicitor, him or herself, has the obligation to provide sufficient information to their instructing solicitor to enable the instructing solicitor to advise their client of the total estimate of costs likely to be incurred in a matter as required under section 174 subsection 1 of the uniform law.
I imagine there'll be some resistance from certain members of the bar to providing those sort of fee estimates where historically they haven't been required to do so. If the barrister doesn't provide or meet his or her obligations, is the solicitor still, I suppose, potentially in breach of their obligation in not obtaining that on behalf of the ultimate client?
Yes, they are in breach, and that is why it is incumbent on a practitioner to ensure that that information is obtained, or reasonable steps are taken to obtain that information from their counsel. Of course, the barrister, him or herself, would also be in breach, and the consequences of a failure to disclose are significant.
And what are some of the consequences generally for non-disclosure under the legislation?
Well, firstly, the costs agreement upon which a practitioner may be relying is considered void. What does that mean? Well, ultimately, it means that the costs would be assessed without regard to the agreement, the provisions within it. Hourly rates, for instance, that may be stipulated within the costs agreement are essentially ignored on assessment.
Would that vary between Victoria and New South Wales, where you have different regimes for assessing costs?
Well, ultimately no, because ultimately the costs are assessed on a fair and reasonable basis. I will qualify that and say that, of course, what might be considered fair and reasonable in one city, let's say Sydney, might not be considered fair and reasonable in another. Similarly, regionally versus perhaps a city, because regional firms may not have the same overheads as a city firm, and so hourly rates might differ.
And in Victoria, you have the scales, of course, which apply as a default to hourly rates.
Indeed, and we may well see reliance on some of those scales, even in New South Wales, in the absence of a valid costs agreement. It may well be that because the jurisdictions are in many ways joined now, there may well be precedent to be relied upon in New South Wales to establish that the hourly rates that are being allowed in Victoria, perhaps in default of a valid costs agreement, should also be applied in New South Wales. And that's an interesting argument I think we'll have down the track.
Are there any other consequences of non-disclosure?
Well, certainly a practice is unable to sue to recover their costs if disclosure has been inadequate, which means, of course, costs would require being assessed prior to recovering costs incurred pursuant to those instructions that initiated the cost agreement itself. That's probably the most important factor arising from the failure to disclose, other than the fact that the provisions of your cost agreement would no longer apply.
And Mike, are there any penalties which might apply where there has been a breach of the disclosure obligations, other than those costs being assessed on a different basis to that set out in the cost agreement?
Interestingly, Paul, the provisions under the Legal Profession Act in both states, Section 317, subsection 4 in New South Wales, and 3.4.17, subsection 4 in Victoria, have been removed. And so those provisions essentially established the discretion available to the cost court or to a cost assessor to reduce costs in an amount proportionate to a failure to disclose. Now, the fact that those provisions have been removed is interesting in itself, and potentially again is one of these pendulum swings perhaps back towards the practitioner. But I would venture to say that the overall discretion of a cost assessor and the cost court arising from the opportunity to assess costs regardless of provisions of a cost agreement open up the assessment process itself to being somewhat punitive to a practitioner given a failure to disclose. That's just an observation. It's unclear yet whether or not perhaps a more punitive approach might be applied in determining what might be considered fair and reasonable, but we'll see over time the results.
Does the uniform law affect individual consumers in the same way as it would apply to large multinationals or corporate clients, if you like, who routinely engage legal service providers?
No, in short. Sophisticated clients, as they were known under the Legal Profession Acts, both in New South Wales and Victoria, are now known more generally as commercial or government clients under the uniform law. There is a lengthy list of definitions in relation to which type of client might fall into that category. But just to give you an example, a local council or a large publicly listed company would be considered a commercial or government client. These clients are exempt from the cost disclosure obligations in relation to in fact, a practitioner's obligations to disclose pursuant to the uniform law. And as a consequence of that, similarly, they are able to avail themselves of the provisions that any other private litigant or consumer of legal services is entitled to under the uniform law, unless, and there are a range of exceptions, unless, for example, the cost agreement they're entering into is a conditional cost agreement. or unless the parties themselves agree to be bound by the provisions relating to assessment and what might be considered fair and reasonable. But by and large, consumers of legal services are exempt from the provisions of the Uniform Law with respect to disclosure.
If you were to speculate, how long do you think it will be before we really get some idea of how the legislation will be applied?
Well, of course, the regime only applies to cost disputes arising from matters in which instructions were first received after the date of 1st of July 2015. As a consequence of that, of course, matters may have been dealt with in a very brief and cursory way. Perhaps a matter was commenced the first week of July. We might see that matter resolved in the courts, potentially over a 3 to 4 month period, and there being a dispute arising between a practitioner and their client about the costs involved. I can't envisage things happening much more quickly than that, and therefore I would say even before we obtain an assessment itself in relation to such costs, the matter itself would take 3 to 4 months, no doubt, to resolve before the assessment process is embarked upon. Of course, in New South Wales, an assessment may not be completed for another 3 to 4 months, even in the most simple cost assessment, because of course a cost assessor needs to be appointed by the court once an application's been made. There are time limits involved in relation to the other party's opportunity to provide details in response to an application. And so in reality, one would expect we probably won't see too many assessments concluded in New South Wales until the end of 2015. I'd be interested in your own views about Victoria.
I suspect it would be at least sort of 6 to 12 months before we'd see any cases winding their way through the cost court. It's very difficult to speculate, particularly with the Legal Services Commissioner, on how actively the Commissioner will be involved in applying this legislation, I suspect. And I think it's very challenging for practitioners effectively having two processes that are potentially they're required to comply with, and particularly the more onerous obligations that are imposed under the legislation. I know a number of firms work on a no-win, no-fee basis. Are conditional costs agreements, which are commonly entered into with those firms, still permissible under the new legislation?
Good question, and one that is a bit of a hot topic for many of my clients. In fact, conditional cost agreements are still permissible under Section 182 of the Uniform Law. However, one should only enter into a conditional cost agreement if there is a reasonable likelihood of success in a matter, and that is made very clear in that section. One of the provisions that has been removed in relation to conditional cost agreements is that pertaining to cost agreements relating to personal injury damages or damages claims. Under the old provisions in New South Wales, if one had entered into a conditional cost agreement in relation to a damages claim, in fact the practitioner was not permitted to recover any costs whatsoever arising from such a claim. I know that differs from the Victorian provisions, but certainly that's a fairly major change in the New South Wales system.
I note a number of these agreements also apply an uplift of up to 25%. Is that still available under these types of conditional cost agreements?
Yes, no more than 25%, but the 25% is available.
And potentially if there was a breach of the disclosure obligations, would a practitioner risk losing the 25% uplift in those circumstances?
In my experience, that certainly happens. It's rare where disclosure has been inadequate for any uplift to be allowed. I'm sure that's your experience in Victoria.
Just moving to a different subject, a number of practitioners still apply or still prepare lump sum bills for their clients without providing a detailed narrative of work undertaken.
Yes.
Are lump sum bills still allowed under the new legislation?
Yes, they are. Interesting though, well, firstly on lump sum bills generally, we would generally advise our clients not to rely solely on a lump sum bill, but to ensure that they maintain accurate records to justify the fees being charged under a lump sum fee. The reason for that being, of course, if they are required to establish why those fees would be fair and reasonable, they're going to be required to provide the evidence that establishes the fee level in any event. Now, in response to your question, lump sum bills are certainly permissible, and in fact lump sum and itemised bills in a combination are similarly permissible. However, if a practitioner does provide a lump sum bill and is then requested by a client to provide an itemised bill, which the client is entitled to do up to 30 days from the date on which the lump sum bill becomes payable, the practitioner must then provide the itemised bill, and if the itemised bill, if the fees sought in the itemised bill exceed the costs in the lump sum bill, the practitioner is unable to recover costs billed under the itemised bill until the costs have been assessed. And so it's important to note that when preparing an itemised bill, one certainly shouldn't exceed the lump sum bill if that's what the client has requested, i.e. the itemised bill.
Where a lump sum account has been rendered, or in fact when any account has been rendered, is the practitioner able to enforce payment in circumstances where the assessment process has commenced under the legislation?
No. Should a client effectively object to the costs being sought, either in a lump sum or an itemised account, the client has an opportunity within time limits to proceed to have those costs assessed. A client has 12 months from the date from which the costs become payable. Now, if I could just point out, if a client is provided interim bills along the way, that time limit does not commence until, even in relation to those interim bills, until the final bill has been presented and has become payable. And so a client has an opportunity to object to the fees being sought in either an itemised bill or a lump sum bill at any stage within 12 months of the final bill being payable. And once an assessment application has been made by a client, a practitioner is unable to recover those fees until the assessment has been concluded.
And potentially how far back could the time period extend?
Well, effectively, there's no limit in relation to that issue. If the matter is extended for 20 years, one would arguably say, well, there's certainly no limit on the costs being assessed from 20 years ago. Fortunately, I haven't seen one go back that far.
And presumably where the instructions have been in relation to the same issue or the same matter.
That's right. And that's an important point, of course. If a practitioner is engaged by a client on perhaps numerous matters, it's always advisable that the practitioner enters into a new costs agreement specifically in relation to each of those matters. In that way, the costs being incurred in relation to each of those individual matters are somewhat quarantined from the other costs, and once each of those individual matters concludes, a final bill can be rendered and the clock would stop 12 months from the date those fees are payable, regardless of whether or not a practitioner is also engaged on other matters for that client.
Are there any other provisions that practitioners should be made aware of under the new legislation?
Yes, Paul, there are numerous, and I would urge any practitioner, and particularly principals of practices, to have a very close look at many of the provisions under the Uniform Law. Section 188, just as an example, stipulates that if a practice provides a client with a bill, a partner or principal of the practice must sign the bill. And if a partner or principal has not signed the bill, then every partner or principal of the practice is taken to have signed the bill.
How does that differ from the previous position?
Well, previously it was not a problem really for an employee to provide and sign a bill. Now responsibility is being ascribed to the owners of the practice effectively. And when that is combined with Section 207 of the Uniform Law, it has some serious consequences, because if costs are claimed within a bill, itemised or lump sum, which are considered not to be fair and reasonable, the partner or principal who has been responsible for that bill can be considered to have acted with professional misconduct, and similarly any associated solicitor involved in preparing that bill and the work in relation to it can similarly be considered acting with professional misconduct.
And if the partner hasn't signed the bill, those obligations can still be taken as to be imposed on the partner?
In fact, the obligations are imposed on all of the partners, because 188 operates to ensure that all of the partners are taken to be responsible for the bill. And our advice to our clients, our practitioner clients, is really to ensure that they quarantine that risk by ensuring that a partner is designated with responsibility for the bill that goes out, and not simply having been signed by the practice, but having been signed by a partner who has been designated with that responsibility, thereby quarantining any risks associated with the professional misconduct provisions to just one part of the firm.
In a busy commercial practice, for example, is it realistic to expect partners to individually sign invoices as they go out?
Perhaps not realistic, but in fact essential as far as the legislation goes. You have to bear in mind the Uniform Law itself was established largely by a panel of judges and consumer advocates, and we're seeing many of the provisions, particularly, I mean, this one is an example, which really go to the heart of protecting consumer and client rights, and thereby putting aside any inconvenience to a practitioner or the firm in a busy practice, and ensuring that the client's rights are upheld.
Do any of the new provisions affect the interest entitlements of the practitioner?
Yes, Section 195 of the Uniform Law stipulates that interest may not be charged on a client's bill if the client does not receive the bill within 6 months of the matter finalising. For obvious reasons, perhaps a client is unable really to consider whether those fees are fair and reasonable whilst the interest is being increased over time. And so there are, again, simple consumer rights being incorporated into the Uniform Law, and this is just one of them.
In summary, Mike, could you perhaps expand on the cost assessment process to assist practitioners in understanding what they may go through if they are subject to an assessment of their costs?
Sure. So under section 199, subsection 2, A and B, it is clear what a cost assessor or the cost court must determine in a costs assessment. They firstly must determine whether or not a valid costs agreement exists, and therefore whether disclosure has been adequately provided. And then the cost assessor and the cost court must determine whether or not the fees and charges therein are fair and reasonable. These are two very clear obligations, and both require consideration in the cost assessment process. And overall, of course, it's important for practitioners to note the types of things that will be considered when determining what might be considered fair and reasonable. There are a number of additional pieces of information that a cost assessor may use to determine the fairness and reasonableness of fees, and examples have been given including the seniority and experience of a practitioner, the time in which a matter was conducted, potentially, for instance, if a matter was conducted over the Christmas break, that may impact on a higher level of fees and charges. The speed with which the matter had progressed, perhaps because of the urgency of the proceedings. These are specifically noted within the Act as considerations that should be given by a cost assessor and the cost court when considering and determining the fairness and reasonableness of fees and charges.
Under the old legislation, Mike, there was a definition of gross overcharging, which I think is where costs have been reduced by 50% or more. That in itself was deemed to be gross overcharging. Is there a comparable provision in the new legislation?
Well, interestingly, the definition itself has changed there, and so the old test of whether fees and charges were considered grossly excessive has now moved to the test of whether fees have been considered not fair and not reasonable. In my view, that is a very significant change. I have acted personally in matters in which costs have been reduced in the amount of $2 million down to $1 million on a $2 million account. Clearly, in that situation, the costs, the $1 million that came off the $2 million were relating to fees and charges that were considered unfair or unreasonable. Similarly, though, I have drafted bills of costs which have been assessed and have been reduced by as little as 1 to 2%. Why? Well, because that 1 to 2% was considered not fair or reasonable in the circumstances. Perhaps because a second solicitor attended a particular conference and it wasn't considered fair or reasonable that that be done and charged for. My point being that both of those scenarios involve costs that would be considered unfair or unreasonable. It's a question of perhaps the case law that we'll see over the years and months and years to come, just where the courts find in that spectrum to be the test as to what might be considered unfair or unreasonable. But the test remains the same in relation to both of those examples. And the grossly excessive test is no longer the key here. So again, it's important for practitioners to ensure their fees and charges are fair and reasonable.
Mike, you've presented many times to practitioners on the new legislation. What would be the feedback you've received, particularly the most controversial aspects of the changes?
Really good question, Paul. many practitioners are struggling with the introduction of the uniform law because of some of the fairly onerous requirements on them in relation to disclosure, but none probably more so than 174 subsection 3. Under that provision, a practitioner is required to undertake all reasonable steps to be sure that their client has understood the implications of what they're embarking upon when they instruct their practitioner, and that they have an understanding of the costs that are going to be incurred in doing so. Now, what really is the question is, what are all reasonable steps? What constitutes reasonable steps? In our view, we believe that a practitioner is going to be required to put context behind receiving an initial instruction to ensure that there's a clear understanding of the client's own level of understanding as to what they're entering into. And so effective communication with your client becomes a really paramount requirement in the instruction process. And of course, that's a two-way conversation. So it will require practitioners to put some context around their client's ability to understand what they're doing.
If you were to speculate as to why that additional requirement's been put in place, what's perhaps an example of what might happen if that context isn't provided to a client at the outset?
Well, one of the provisions that's been removed from the Legal Profession Act relates to providing a translator or perhaps a translation of the costs agreement that the client is entering into where necessary. And so because the onus is now on the practitioner to take all reasonable steps to ensure their client has understood what they're embarking upon, the onus is on the practitioner to determine whether or not a translator is required, a translation of the cost agreement is required, perhaps a more extensive initial conference is required because the overall understanding of that client's it may fall short in relation to a relatively short instruction. And so what we are advocating practitioners do is perhaps set up a pro forma document identifying some of the issues that they will regularly need to determine when putting instructions into context. And so, for instance, questions to the client as to their experience in embarking on, let's say, litigation, whether or not they've ever engaged counsel before in a matter, perhaps what level of education they have. Really evidence to establish that all reasonable steps have been taken to ascertain that the client is understanding what they're embarking upon. And that's the intent behind that provision. Mm-hmm.
Mike, we've covered many aspects which appear to place considerable onus on the practitioner to account for their time to explain to the client the basis upon which they're instructed to act, and then potentially to be involved in a cost assessment process which no doubt is protracted in many cases and expensive. Is there any way for the solicitor to recover those costs or recover the fees for time spent, first of all, in accounting to the client, and secondly, in resolving a cost dispute?
Good question. Unfortunately for the practitioner, no. The practitioner is not entitled to recover the costs relating to keeping a tally or an account for a client as to their fees, for rendering the account to the client, or even for seeking recovery of those costs from the client, with the exception, of course, where a client has perhaps had a matter assessed and a determination has been made by a costs assessor or a costs court as to the fees recoverable by the practitioner, Once that quantum has been determined, the practitioner may then undertake steps and incur costs in recovering payment of those fees. But in terms of actually determining what those fees are, unfortunately for the practitioner, that is considered in many respects a cost of doing business that simply can't be passed on to the client.
Mike, I'd like to thank you for your time today. It appears that this is, in a sense, the tip of the iceberg. There seem to be a lot of other issues and possible consequences of these changes that maybe we can explore at another time.
Yes, thanks Paul. It's been a pleasure to talk with you today about the topic. Certainly there's a lot of interest and, dare I say it, confusion about the new costs regime and requirements on practitioners, and I'm sure we'll have lots more to discuss in the months and years ahead.